Good morning, friends. We are going to discuss a case law on the Limitation Act. Time and again, so many times I have been telling you that Section 5 of the Limitation Act applies to only appeals and applications. Applications like interlocutory, that is injunctions, stay orders. Yes, definitely if there is delay, it applies. That means the delay can be condoned. Likewise, even for appeals, yes, normally you are supposed to file the appeal within 60 days, 45 days, things like that. But if you are not able to get the copy of the judgment, there may be so many reasons. You have to change the advocate, other advocate may not be able to study or prepare the appeal matter. So there will be definitely some delay that can be expected. But please remember, the condonation of delay will not be applicable to suits. So many cases are there, catena of cases are there, but still people file the same under one pretext or the other. So don't be under the wrong impression that this man has purposefully or innocently filed. He knows it, but still he wanted to take a chance, that's all. But Supreme Court found the same. Supreme Court, he clearly held that the power to condone delay under Section 5 of the Limitation Act applies to only suits, applies to only appeals and applications, but not the suits. Right? While dismissing the appeal against the Gauhati High Court judgment, Gauhati High Court has correctly stated. So, while dismissing the appeal against Gauhati High Court judgment in the case of F.Liansanga, so Arunachal Pradesh people, Mizoram, F.Liansanga versus Union of India in SLP number 32875 by 2018 on 2nd March 2022. Two judges, Madam Indira Banerjee and Hrishikesh Rakar and J.K. Maheshwari. Yes. They held that Section 5 of the Limitation Act applies to appeals and applications only, but not to the suits. This is the law. But still, how it has come, we have to know. Very simple to say, I think, do you not know? Definitely you also know that Section 5 applies to only suits. But how the advocate has turned to twist the matter, that is what is important in this particular case. Right. So, this happened in Mizoram state. Limitation is made applicable to Mizoram state right from 21/1/1972. Right. Here, if you know the facts of the case, it is better for appreciation. So, the plaintiff, that is F.Liansanga, he was given a patta for to occupy certain land. Yes, he was cultivating the land. But during the year, actually he was given the patta in 2001. During the year 2002, next year, the chief engineer of one project, that project name is Pushpak. So the chief engineer of project Pushpak came and requested him to allow quarrying in his land, in that patta land, because they have to construct a highway. So in the nearby area, the government wanted to construct a highway in the nearby area. Therefore, they wanted quarrying. They wanted his permission. Yes, he allowed, and those people promised to pay the money also. But you know the government, they did not pay the money. Ultimately, they allowed quarrying for construction of the road, but no compensation was paid. So the compensation he expects is 1,01,200 rupees. So therefore, there is no other go. He has to file an OS. Yes, he filed original suit number 4/2010. But there was a delay. Please remember, there was a delay for the request for the special performance. So he filed a plaint under Section 26 of the CPC. Then plaint is, you may be knowing, under Order 7, but it was rejected under Order 7, Rule 11. You may be knowing. So, Rule 11 says, if the plaint does not contain any cause of action, if it is barred by law, or if it is barred by the limitation, barred by law means barred by limitation. So, it was rejected. The trial court rejected the same. Then, ultimately, what they have approached the High Court. High Court also said no. At the same time, what they have done? Now, they have converted into a money suit. So, they filed a money suit number 60/2011 next year. Same thing. Of course, here the trial court accepted the delay of condonation 325 days. When the matter, immediately the state, that is Union of India went against this order for review by the Guwahati High Court. Guwahati High Court said no. The suit should be, whether it is a money suit, whether it is original suit or whatever it is, it should be filed within time. If you don't time within time, no. Section 9 of the Limitation Act, what does it say? When when the suit starts running, and if the limitation starts running, it will continue to run, it will not stop for anybody. Therefore, Section 5 does not apply to suits. The Guwahati High Court is 100% correct. So please remember. So now the Supreme Court held that the High Court is 100% correct and the appeal is liable for dismissal. Okay. So very good judgment. Every time I have been telling a number of decisions I have given. If you go through my videos, you will definitely know it. So anyway, with this we are stopping. Thank you very much.